Hello, everybody. This is Mentor Lawyer with Judy, a guest from AA Legal Focus. You can say hello, Judy.
Thanks for having me.
Today we had a case management conference in the case of State of Florida versus Donna. There were several interesting things that came up during the hearing. First of all, I think everybody wants to know, is this trial going to still happen in September? And the answer to that is yes, it looks like it's going to go forward. Everybody's planning on doing this trial and getting it done with in September. So a few things that happen of interest. And by the way, what we're going to do here is we're going to give you a version of the hearing video with all the sound issues fixed, with entire video shown, with you being able to see Donna on the Zoom. You also get to see the courtroom. Also, at the end, we're going to redo the video that I published, that I did myself, and I published at 1 a.m. last night, where I had Stephanie the Sleuth narrate the texts. So things that happened at this hearing include the fact that the defense announced that they're going to file several motions. One of the motions that they mentioned, for example, has to do with trying to strike the testimony of Detective Corbett. I'm not sure if he's a detective, but he's the guy that is the IT guy that talks about the cell towers, the cell phones. And my thought is they're probably going to try to strike him, or at least part of his testimony, because his testimony was key, for example, to establish Donna stopping by the house with a wet cache, right? So his testimony about the car being in the vicinity and all this stuff, I think that that's probably what they're going to be aiming at to strike. So they're going to be filing several motions. The other interesting motion that they mentioned to me was the fact that they're trying to change the courtroom where the trial is going to happen. And they want to put it on the courtroom B, which is the usual courtroom where Judge Everett has his trials. It is the courtroom where I had, I guess, the last felony trial. So I actually have a trial in that courtroom on my channel, and it is really small courtroom. And there's almost no media room at all. There's a teeny tiny little room for the media that is like smaller than a hotel bathroom, let's put it this way. So for the media, it would be horrible. Why do they want to do that? I think it's because they want to reduce the number of people that can see this trial, and therefore they think that maybe a lot of people in the audience distracts the jurors, gives them a sense that this is a very important case. They want to make it as small as possible. I think it's a silly motion and it should be denied. But I mean, obviously, there's going to be arguments made, a response is going to be made. We'll see what happens. The defense announced that several witnesses are going to testify for the defense. I'm assuming that Donna will testify. They're going to double down, I guess. And she's going to testify. It's going to be a different story for her, of course. And she's going to have several witnesses testify for her. So the defense announced that they're likely that this trial again is going to be 2 weeks instead of 1 week. You know what happened last time? Then Rashbaum announced a huge defense case, and then the last second pulled all the witnesses, and then it was only Charlie. So we'll see what's going to happen, but they're announcing a huge amount of witnesses for the defense as well. The date when they're supposed to exchange witness list, all the stuff still remains August 12. Except that they moved back to September 4, the date when they're supposed to do the demonstrative aid. So anyway, those are the main things that I mentioned. I may remember something else. But Judy, what was your impression of what happened and what are your thoughts?
Okay. Well, I think most people are fixated on what Donna looked like. And she looked very happy. Were you surprised? She seemed so jovial, like joking with the judge.
Well, I actually did not. I did not see it because I was in the courtroom.
Oh.
And there was a Zoom, right? So I didn't see the Zoom. So obviously, you can tell me about that. Why don't you tell us about that? I didn't see it.
Well, her face definitely looked fuller. So it looks like she's gained a little weight. Before her cheeks were so kind of sucked in. But, she's probably gained like 10 pounds. And she had these nice tortoiseshell glasses, and she was just like smiling and looked very happy for somebody who's in jail.
Okay. Oh, that's interesting to hear. So I guess she's handling jail a little better than her son. I remember that a lot of people didn't think that Charlie was handling it so well. But
Yeah.
I mean, good to see. I mean, she still has to be proven guilty, and I'm glad that she's doing okay in jail. So that's good to hear.
Yeah.
We'll see what happens with the trial.
Yeah. Did you hear that she's actually taking sewing classes and creative writing?
No, I did not hear that.
Oh,
No.
okay. True Lifestyles reported that.
Oh, interesting. Okay.
Yeah, how nice. So what do you think about the defense's possible motions? Do you think I think they would get denied? What do you think?
Well, I'd like to see what they come up with
Yeah.
before I
Yeah, you're very careful with making these
Well, I mean,
conclusions.
look, I totally see why they would want to try to strike this testimony, right? If it is about the situation of Donna driving by Charlie's house, I mean, that was pretty damning piece of evidence, right? And it corroborated Catherine McBanua's testimony, and Catherine McBanua was someone who could be easily challenged as far as her credibility goes, but now they found corroborating evidence that is objective in nature, and that's the kind of evidence that you want to corroborate a line. A witness that everybody knows is a liar, a known liar, a person who lied in court. So now, of course, when you have objective evidence that corroborates what she says, they want to try to strike that because that's enhancing the testimony and the credibility of Catherine McBanua. And Catherine McBanua was, basically a key witness, I guess, against Charlie, and Donna apparently is going to be, because she's going to be testifying about this wet cash and the fact that it must have been dropped off by Donna. So I think that that's what they're striking at. They're going to try to do everything possible to address that issue, the speculation that this was wet money that came from Donna, the fact that it was washed before, all that stuff I think is going to be a key area of focus of the defense. If I were the defense, I think that that's what I would focus on, because it was allowed at Charles' trial, and Donna wasn't a defendant there. She did not have her own attorney, but now the case is against Donna. And that was damning testimony against Donna before she was at trial. So now she has an opportunity to challenge those pieces of evidence against her.
Yeah. Although Katie was just speculating. She didn't know for sure.
But that came in. But that came in at the trial, right? It did come in. And
Yeah.
so I think that maybe it surprised Dan Roshbaum a little bit, and maybe he didn't react in time. And now, obviously, they have a lot of time in their hands to prepare.
Yeah.
And that's one area that I think that they're going to go after. I mean, I haven't thought it out thoroughly to think of what else are they going to challenge from him. I don't think that they're going to try to disprove the fact that Sigfredo Garcia and Luis Rivera did the murder and all that stuff about Catherine McBanua and stuff. But they're going to focus on the testimony about Donna and Harvey stopping by the house, because I think that was corroborating Catherine. I think that's the focus. The defense said they're going to be taking several depositions, and that they're going to be going through the discovery that was just disclosed, and that they're going to use some of that potentially for the aids, the demonstrative aids.
What about switching courtrooms?
Yes, the change of courtroom. I've never heard of such a motion before. And the fact, the argument that the size of the courtroom affects your due process sounds a little bit strange. I mean, this is supposed to be a public trial. It is supposed to be a trial that everybody gets to see. And, the judge is in control of the courtroom, is going to be able to control behaviors in the courtroom. And Judge Everett does an excellent job managing that. I don't see what kind of argument you can make that having a bigger courtroom deprives you of due process. I mean, I don't see how you can make that a winning argument.
Well, what would happen if too many people come to the trial? Do they have like a overflow room for spectators?
No. So this is 100% in control of the judge. So the judge is in control of what happens in the courtroom. So obviously this is supposed to be a public forum. And the way that the courtroom is organized is you have a few benches for the media, and then the rest is for the general public. And so the judge usually should allow the public to come in and watch because this is supposed to be a public trial, right? What the judge can do is he can, limit the access into the courtroom once it's full. He can limit the access into the courtroom in between breaks or while testimony is happening. He can say, hey, as soon as the testimony starts, nobody comes in and out, unless there's an emergency, of course. But overflow, no. I mean, if there's not enough room, people have to wait outside. There's a first come, first serve kind of situation.
So you could just go there to Tallahassee and not be able to potentially see the trial.
Maybe that's one of the reasons, right? So if you're gonna have a smaller courtroom, he's trying to detract people from traveling here because there's not going to be any room and they're going to be outside, and watching on your cell phone on Deep Dive True Crime instead.
Yeah, exactly. Well, I'm still going, and everybody else on YouTube, we're definitely planning to go, so it's not gonna deter us.
Monday. All right, while we're waiting on the jail, I'll allow the parties to make their appearances.
So Catherine Dean on behalf of the state.
Alex Morris on behalf of Ms. Adelson.
Matt Fromm on behalf of Ms. Adelson.
All right, as soon as we can get things straightened out with the jail, we'll go ahead and make sure Ms. Adelson can see, and at least see and hear me. She'll be able to hear you all through the mics. If you want to log in, go ahead and do that now yourselves, please. Right, I see her now. Ms. Adelson, can you hear me?
Yes, sir, I can.
Okay. Give me one moment. I only hear your audio coming through, not the overhead speaker. Right, can everyone hear me?
Yes.
Isaac, I think this is only coming through my computer. Right. Ms. Adelson, I want to test your audio one more time. If you can tell me the name of your high school mascot.
It's been a few years. Oh my God. I cannot tell you. I don't remember my high school mascot.
These are the things that are burned into the brain, but anyways, not why we're here. We can hear you now over the loudspeaker. So the video and your audio is working. All right, we're here today for a status before we get to, I believe, some of our cutoffs and also our deadlines. I'll allow both parties to be heard if the state wishes to go first.
State does not wish to be heard today. We're ready for trial and intend to comply with the deadlines that the court gave. The defense and I did have one agreement about a deadline that they possibly wanted to push back by, I believe, 2 weeks. They had asked if they could push back the demonstrative exhibit deadline until September 4th. We don't have an issue with that. We believe we'll be able to comply with everything in the judge's order. The only Sergeant Corbett's presentation sometimes can take a little longer, as I know last time. It changed a couple of times before trial, just minor changes that he made. We were able to keep defense up to speed with that and had agreements as to that. We've talked about that and intend to do the same thing this time if we could have the deadline of September 4th for our demonstrative exhibits. We can give him a pretty finalized rough draft of that by that point, and any minor changes that do need to be made, talk to the defense about that after that time.
All right. But the defense can explain why you'd like this to be pushed back. And the only reason I ask this question is because once everything is filed pursuant to the deadlines, we need to have probably at least a 2 or 3 hour hearing on all pretrial motions. So I don't want the start of the trial to be bogged down by needing a ruling on a particular issue or motion, but I'll allow you to explain.
Judge, I think the construction of some of the demonstratives, obviously I'm new to the game, so to speak, but in this case is a different case factually from those that have been tried before. But just the construction of them and meshing them with electronics that we're going to have available. I would just like, we've gotten some new discovery in recently as well. That is going to be incorporated into our demonstrative, so it's just a little bit more breathing room to be able to get it done.
And I assume both sides are going to want the headsets and the various audio media aspects for the jury once again.
Yes, sir.
Yes, sir.
Very well. Then going back to the order setting the procedure dates and also the deadlines as far as any demonstrative exhibits, then I will permit both sides to have until September 4th to ensure all demonstrative exhibits are traded between the two parties. As far as the witness list and the exhibit list itself, there's really no reason why August 12th that cannot be met, correct?
That's fine, Judge.
But that's correct, and we would like it to be so and maintained. Likewise, Judge, we do have an agreement. We spoke with Ms. Kappelman with respect to some of the exhibits and the manner in which they're listed. By way of example, Donna Adelson emails, but it won't be more specific than that in the prior listings that have occurred. And so we've talked to Ms. Kappelman about them being more specific when they're listed, with the understanding and the caveat that that would be a rolling list that could be supplemented. The exhibits could be supplemented. It's just to bring focus to, rather than digging through 50 hours of recordings or 5,000 emails to draw everything to focus. So you don't need to do anything on that. That's what our agreement is. But on the our August 12th deadline would remain the same for everything with the exception of the demonstratives.
All right. Do we need to address the modification to the trial date any further as the September 17th being the first day of selection?
No, sir.
I don't think so, Judge.
All right. Time-wise, I would expect we're probably going to be similar to the last trial where we have at least 3 days or 4 days of selection. Assuming we are successful, we would get started, and then we would have about a week or maybe a week plus of trial. Do the parties have a differing expectation of this?
We sketched out the number of witnesses, and some of it is will be more focused once we get to August the 12th, but I had some concern based on the volume of witnesses that we had agreed on. It would be a solid 2, if not more.
Good thing I help everyone along in this process.
Well, now that may drastically contract, and because there are several of the witnesses that are very, very short, and they're simple things, and we may even arrive at stipulations to knock those things out of the way. But I would be leery of telling you that it would all fall within the confines of 1 week. I feel like 2 weeks we could push hard for.
Okay. Well, you have until August 12th, I should say, to iron out aspects of this. Ms. Dugan, at least preemptively, would you expect the state's case to last for about a week once again?
Yes, sir. And I think last time, or the last 2 times we have been able to pick a jury in 2 or 3 days, and the state's case took about 5 days. I would expect for it to be about the same.
Very well. Are there any other issues that either party needs to raise for the status as of today?
Judge, we're going to be filing several motions, some of which you've never heard before. And some of them are going to deal with, for instance, just so the other side knows, we are going to move to preclude Sergeant Corbett's testimony, which will obviously affect the demonstratives, but we think we can do that even without seeing the exhibit. But one of the motions that we intend on filing, I just want to let the court know of beforehand because it might affect scheduling of courtrooms. We're going to ask that the trial not be in this courtroom.
For 3G?
What's that?
For this courtroom, 3G?
Yes, we're going to ask that the trial be held in your courtroom 3B. And we have a variety of reasons why we think that courtroom will afford our client better due process than this courtroom does. And so we're filing that motion, and we'll file it on time. But I just want to give you a heads up so that if there's a scheduling issue, you're aware that that motion is going to come down the road.
Very well. Literally, until I see the motion and the state make its argument, I won't be able to make a ruling on it, and that'll happen in time. As far as selection itself, though, we may still need to use this courtroom just to hold the sheer volume of prospective jurors that are needed, but as to the courtroom the trial will occur in, that certainly we can address with the motions.
And the motion, I should have said that, the motion contemplates that jury selection would still be in here.
Right. Ms. Dugan, any additional matters the state needs to address for today's hearing?
Yes, sir.
Very well. To go back to the scheduling order, our next set of deadlines will be discovery on August 12th, the motion filing deadline August 12th, the witness list and exhibit list also on August 12th. And I believe our pre-trial hearing, not referring to motion hearings that will be filed, but just the final pre-trial will be September 12th at 9 o'clock. Mr. Morris?
With the advent of some of the new discovery, we're endeavoring to take a few depositions. We've worked with Ms. Kappelman and also Ms. Dugan to be able to coordinate those by Zoom if necessary because of travel and things of that nature. The reason I bring it up, there's probably a chance that there are depo dates that are going to be after the August 12th date, but they will be set and noticed at that point. I hope that would be
set, notice, meets the deadline, hopefully so this doesn't become a similar issue like it did last time. If we need to address a particular aspect of discovery that needs to occur, possibly after the 12th, go ahead and move in advance for that so it does not become an issue of anyone violating the deadline or attempting to take or seek discovery after the deadline is passed. Okay? All right, with that being said, this status is coming to an end unless anyone has anything else you need to bring to my attention.
from the defense judge.
Nothing, sir.
All right.
Ms. Adelson, were you able to listen and follow along to my discussion with the attorneys?
I could hear you. I could hear nothing that the attorneys were saying.
All right.
I really can't ask them to repeat themselves in full, but your counsel have asked to set back on the deadlines to September 4th. I have agreed to do that concerning demonstrative exhibits. All other deadlines are going to remain in place. They will speak with you concerning any other issues that you need to discuss with them about today's status, okay?
Okay, thank you.
All right, we are in recess. Have a good day, everyone.
Hi, I'm Steph the Sleuth, and Mentor Lawyer asked me to play the role of Donna Adelson and Wendy Adelson as I read their instant messages to each other, texts that were sent between 11/6/2023, the date Charles Adelson was convicted of the murder of Wendy Adelson, ex-husband Dan Markel, and 11/13/2023, the date Donna Adelson was arrested for the murder of her former son-in-law, Dan Markel, at the Miami International Airport, where she was about to board the first leg of an international flight that would ultimately take her to Vietnam. I will read the texts, trying my best to change my voice for each of them, listing who is the sender and the date and time the text was sent. We will also be showing you the actual text on screen, so you can follow along as I read each text. So, here we go. On 11/6/2023, Donna sends a text to Wendy at 5:31 p.m. Your brother protected you for years. Now you are not guilty. Your law lawyer took very good care of you. You can bury me in the dress that I bought for Lincoln's bar mitzvah. This text from Donna is the most incriminating, according to Mentor Lawyer. The sentence, your brother protected you for years, in context, can be interpreted to mean that Donna Adelson knows that the extortion defense Charlie testified about at trial is false, and that she knows that Charlie was lying, in part to protect Wendy. This suggests that Donna knows or believes that Wendy was involved. This interpretation is buttressed by the next sentence. Now you are not guilty. A fair interpretation of this sentence is that Donna knows that Wendy is complicit, but now her story is that she had nothing to do with it, and now that her brother is convicted of the murder, Donna may believe that Wendy will never face justice. The next phrase, your law lawyer took very good care of you, suggests that Donna believes that Wendy's lawyer took care of her without caring for how what he did to take care of Wendy harmed the other Adelsons. And now Charlie has been convicted, in part due to Wendy's testimony. You can bury me in the dress I bought for Lincoln's bar mitzvah. The final sentence is reasonably interpreted as Donna trying to make Wendy feel guilty for getting away with it and helping convict her brother, who did do the murder to protect her. At least, according to Mentor Lawyer, this is how prosecutors will likely argue the meaning of this strong piece of evidence. Donna sent the following text to Wendy on 11/6/2023 at 8:15 p.m. We know you never ask anything about your brother, but we just got off the phone with him, and the first thing he asked was how's Wendy holding up? I didn't have the heart to tell him that you never called us or asked about you. I just said we weren't up to phone calls right now. Everyone looks to protect you. I bet you've got a lot to think about. Wendy responded the following day at 10:10 a.m. Dear Mom, I know you're upset by the verdict, but the anger directed at me is not justified. I am not responsible in any way for Charlie's situation. I am not guilty because I did not do anything wrong, and I was not involved in any way with Danny's death. When I was interviewed by the police and testified in court, I told the truth, as I was required to do. I cannot control how the prosecutor uses my statements at Charlie's trial. Also, as you know, my lawyer has advised me not to talk to my family or anyone else about this case. I followed his advice despite your disagreement with this guidance. Please do not text me about this case anymore. If you have anything further to say about the case, please go through our lawyers. Right now, I have to be singularly focused on taking care of the boys during this difficult time. At 10:19 a.m., Donna responds, Okay, we have no desire to speak with you about the case. I guess Dad and I are just shocked that you didn't think of coming to see us or even calling us. We are your parents. We are and have always been there for you and the boys. None of what we wrote matters about the case. That's over. I just wanted you to know how many times Charlie is asking about you. Not only do you not ask about us, but not one question about Charlie. We will need to give you some information shortly and need some business assistance. Please let us know if you can be of any help. If not, we'll try to find someone who can help us. This needs an immediate reply so I can start asking other people for help. And she follows at 10:30 a.m. Don't get nervous. Again, nothing about the case. Just would like to show you business stuff and personal things. If you can't do it, we must find someone who can. I hope you understand that it has nothing to do with the case. There is no more case. At 11:01 a.m., Donna continues, By the way, you said that you had to focus on the boys. Have you told them? 3 days later, at 8:09 a.m., Donna continues, I don't know if you were in the car taking Ben to the airport, or if you've already done that. Please give us a call when it's a good time, because we need to see you for some things today, with or without redacted name. Either will be fine. I don't know if he has plans. At 12:08, she continues, I never looked at the list of people you invited to the bar mitzvah, but I haven't spoken with Luella in months. We have texted about once a week when she tells me what else is wrong with her, another cold, another cough, headache, back, to another doctor. But we actually are just occasionally text message friends again. I don't know if you invited her or not, but she really is no longer a friend. I also hope you did not invite Seth and Jen. I only last spoke to them 6 months ago. I don't hear anything from them. And at 12:09, the final text sent from Donna. Too much going on, and I don't mean to bother you with this. But again, I have no idea who you invited. Okay, so that was the last one.
I feel very optimistic. And, really big thanks to you for covering this case from the very beginning and getting us all this great information, which I don't think most people would know if it weren't for people like you. I'm just happy to support your channel, support the other YouTubers who are just helping to bring justice for Dan. So
Oh, that's awesome.
thank you. Yeah.
so much, Judy, and thank you for joining
Okay.
us and joining the coverage. The videos that I've watched that you have done, I have always enjoyed them, and I've liked our collaborations, and I look forward to doing more. Okay.
Yeah. Okay. Great. Thank you.